All right, and it looks like we're good to go now. And as I said, I do want to talk with you about something that I consider to be quite serious today. And so many of us, I imagine, tuned in to the arguments at the Supreme Court on Thursday around Donald Trump's claim to absolute immunity from prosecution for activities undertaken while in the office of the president. And of course, those activities are indicated in part on the images on the board. The case in particular concerns the effort to overturn the 2020 presidential election results, where the lawful results showed that Donald Trump had lost that election, and he engaged in a number of efforts, including trying to influence state level political officials like Ben Raffensperger in Georgia to change the vote count, tried to assemble false slates of electors to um, ultimately throw the decision about who was president out of the constitutional mechanism in the electoral college and into Congress, where he thought he could prevail, tried to bully Mike Pence into not doing his legal and constitutional duty when he chaired the joint session that was meant to register the outcome of the electoral college results, and ultimately also uh and this is the allegation, and I want to be as clear as possible. We don't know the outcome, but we have enough information in front of us to begin forming our own judgments. Mobilized a crowd to invade Congress in order to disrupt the seating and proceedings of the Congress considering the Electoral College vote, authorizing the outcome of the election, again, delaying the intervention to bring that crowd back under control in the hopes that this would change the outcome of the election. And I'll start with an observation from an NYU law school professor, Melissa Murray. I heard her interviewed on Thursday morning as this question was going in front of the Supreme Court. Should Donald Trump be immune from criminal prosecution for everything just mentioned because in acting as president of the United States, he has complete or absolute immunity from criminal prosecution? And Melissa Murray, when interviewed, said, well, no legal scholar believes this argument has any plausibility to it. The question is about how quickly the Supreme Court decides, not about whether or not the argument is actually going to succeed. And then an hour later, we realized that Justice Alito, Justice Clarence Thomas, maybe Justice Brett Kavanaugh seem to be taking the argument very seriously. And so the idea that the legal community thought this argument had no plausibility turned out to not understand where the justices of the Supreme Court, at least several of them, were coming from, and how they would regard these arguments. And so this seems to me to raise a number of issues. And to be honest, I wasn't planning on speaking with you about this today. I, like Melissa Murray, assumed that there wouldn't be any shocking developments on Thursday, that the real question was more around the timing of when the Supreme Court would actually find or render its decision in this case, release its opinion. Now I have to focus on this. And I have to focus on this because it seems to me, in particular, something that Justice Samuel Alito said really is quite dangerous. And what it reveals to me, and I'll elaborate this in much greater detail as we go through today, is that the world that Melissa Murray and I think many of you listening to me today occupy is a different informational world. It's a different knowledge base, it's a different system for generating that knowledge than the world Samuel Alito occupies. And what Samuel Alito's questioning and it appears several of the other justices questioning reveals is that they do not consider what the special counsel, right, appointed in the Justice Department to investigate this, what the multiple legal investigations, what the grand jury concluded is, in fact, a legitimate exercise in law. They are at least willing to consider, give some credence to the idea that this might be purely vindictive, purely a witch hunt, that the frame that Donald Trump has tried to impose on the efforts to hold him legally culpable for the efforts to overturn the election. And legally speaking, I have to say the alleged efforts, he has not been found guilty of any of this. But as someone who, as a citizen, gets to use my judgment to determine what I believe happened, I do believe that the evidence is overwhelming that Donald Trump took every opportunity he could to use the powers vested in the office of the President of the United States, which he held until early January of 2021, to overturn the lawful results of the election. And that it appears that Alito and Thomas and maybe others of the justices do not believe that that's an accurate description and instead believe that this may be purely vindictive behavior on the part of Donald Trump's successor, Joe Biden, and the people he's appointed in the Justice Department, as well as partisan prosecutors in New York and Georgia. And I just have to admit to you that I did not expect this from the Supreme Court, from the justices of the Supreme Court of the United States. And in particular, what occurs to me in light of this is that the role of partisan identity in shaping our perception of social reality has become so structuring, so dominant, that it is infecting aspects of our legal system, of our knowledge system, that I thought, frankly, would be less affected by this than it appears they are. And saying that, I recognize that perhaps in retrospect I was being naive and that I was perhaps idealizing the Supreme Court and its justices, and that I should know better than that, especially in light of stuff we've talked about together before about how this institution has become increasingly politicized and polarized, how there's been this 50 years sustained battle to reshape the court, to remake the Constitution and the law, to put a very different kind of imprint on it. But I frankly still had this residual hope that the court would stand up for the core pillars that support the rule of law in our society, if for no other reason than because its own institutional interest indicated that this was the only path available to the justices. Having said all of that, I will, of course, immediately notice that the court has not issued a decision. And there's, I think, a pretty likely scenario in which the three justices appointed by Democrats may join with a couple of justices appointed by Republicans. It seems to me John Roberts, the Chief Justice, and Amy Coney Barrett, the last of the Trump appointees, are good candidates to join with Sotomayor and Brown, Jackson, and Kagan in constituting a five-member majority in at least limiting the immunity that the president enjoys because he occupies the office of the presidency, and hopefully limiting it to a very constricted range related to performing core functions of his office. I don't have the precise standard in mind, but I'm assuming that they can elaborate it and we can debate it. But the more I think telling thing is the actual line of questioning at this moment, and how deeply it shows that our epistemic world has fractured, and how that is influencing all of the institutions that we rely on to establish the truth, to establish the rule of law, to organize our shared social life together, and how deep the jeopardy is to those institutions. So the question, right, what happens to the rule of law when the Supreme Court engages in partisan motivated reasoning is the core question today. We have the images of what happened on January 6, 2021, because I hope that these images have some power to reinforce the basic, brute, factual reality of what happened on that day. And then, of course, this cartoon that I like, which amendments protect us from the Supreme Court, which brings to mind, of course, that if we view the Supreme Court as in some sense above politics and the uh, last resort in protecting us from our worst instincts or the worst tendencies of majoritarian or minoritarian tyranny in the United States, we are mistaken in thinking that the court automatically or always does that, as opposed to it being a product of a certain kind of politics, constitutional politics, that gets us a court that can do that. So those are the issues that I want to focus on, and so I'm gonna maybe change the order here a little bit, and I'll be really fast about this. This is not the only place that Donald Trump was in the court system. He was, of course, also in the court system in Manhattan, and I think this is salutary, hopeful to recognize that a ordinary state court in our federal system, right? So this is a New York state court, not the federal courts, and so it's not governed by the uh, complicated issues that determine what the Justice Department does. That there may be some safety in federalism in this regard. And then I'll just add very quickly um, that this court seems to be operating more or less in the way that we would hope a court would operate. Obviously, it is prosecuting Donald Trump, and it is prosecuting him on the basis of a complex legal theory of criminality, because right, and I'll be very brief here, right, that the evidence is emerging, and it does appear that there are mounds of evidence to support the fact scenario that Donald Trump had an agreement with David Pecker, who was essentially running the National Enquirer, that Pecker would catch and kill stories that would be otherwise damaging to Donald Trump, and that Donald Trump would reimburse him for having swept under the rug those damaging stories, and that this had happened at least a couple times already in 2016 when the adult entertainer whose performing name is Stormy Daniels started shopping her story. David Pecker detected this, passed the information on to Trump for various reasons, was unwilling to buy her story for Trump. And so Trump arranged for Michael Cohen, his attorney and fixer, to directly pay Stormy Daniels for her silence in the buildup to the election, that she was paid $130,000, that Trump eventually reimbursed Cohen, but did so as a business expense related to legal fees, and that the result is that he is guilty of uh, fraud, or the term, uh, let me just go forward, right, that is used here. I'm sorry, maybe it's not used here, but that he did not accurately, in records he filed, uh, indicate what his expenditures were for. All of that would be criminal if it were caught within 4 years, but it hasn't been. And the reason that the prosecutor is able to bring this case in 2024 around events that happened in 2016 is because the allegation is that this is a campaign expenditure. And so this is campaign finance fraud, not declaring this as an expenditure. And I just point this out because I think the theory is actually somewhat complicated. And the result of the complications of the theory mean that it's not clear to me that Donald Trump will be convicted in this case. And that is as it should be. We should ask our juries and our court system to establish legal culpability under the law in these kinds of complex cases. And so in that sense, I think the legal system is operating as it should in Manhattan this week. I'm just going to very quickly share with you a little bit of further information about what might happen if Donald Trump is convicted, and what might happen. And there's the language, falsifying business records. Sorry, that's what I was struggling to come up with, right? What might happen to public opinion in light of this trial. And so this is a quite recent poll conducted by Politico, pretty good poll, over 1,000 people in it. And what it shows is that 50% of the American people think that Donald Trump is guilty in this case, that there's a sharp partisan skew, and this goes to the way in which our partisan identities are shaping our perception of reality, right? 60% of Republicans do not think that Trump is guilty. Only 3% of Democrats do not think that he's guilty. I'm in the 10%, I think, who right now is not entirely sure about this, but 86% of Democrats think that Trump is guilty. I think the worrisome thing for Donald Trump from a political perspective, from the perspective of public opinion, is that 54% of independents think that he's guilty. Now, let's notice, right, what would happen if he were in fact convicted, and that 32% of the American people suggest that this would make them less likely to support Trump. Now, a large portion of that group is probably Democrats, and that probably has very little bearing on how they're actually going to vote, right? So if they were, 99% unlikely to support Trump, and this increases it to 100% unlikely, that's not a meaningful budge in the numbers. But having said that, I do think that the fact that 36% of independents say that this would make it less likely that they would support Trump again may be significant for the formation of public opinion for electoral behavior in November of 2024. Now, having said that, I just want you to notice for a moment that only 9% of Republicans say this would make it less likely that they would support Trump, but 34% say that it would make it more likely that they would support Donald Trump. And again, this helps to illustrate the broader point I want to talk about in terms of the partisan shaping of perceptions of reality in the 2020s. How could conviction in a right? Falsifying business records case with all of the salacious details. He had an affair with a porn star, is the allegation, right? That it happened when his son was just a newborn, that he then paid her to cover up the story. Doesn't sound like the stuff that we want out of a president, particularly a president representing a party that has claimed to represent the moral majority, evangelical voters, Christian nationalism, traditional morality. This doesn't sound like the stuff of traditional morality. The issue is that Donald Trump has succeeded in framing this issue as one of partisan payback and persecution. That the only reason that he is being put on trial is because a partisan district attorney in ultra blue Manhattan wanted to please his constituents by going after the man they all hate. Why do all those rich liberals in Manhattan hate Donald Trump? Because Donald Trump has courageously stood up for those people who the white, well, I'm sorry, the liberals in Manhattan consider the deplorables, the white working class, traditional, real Americans, and that his conviction would further consolidate his standing as courageous and self sacrificing in being the only politician of the last 50 years standing up for those who are left out and despised by the elite across the board. This effectively makes Donald Trump a political martyr for his supporters. And again, I recognize that as I say this, that I don't consider this to be very plausible, and I don't think many of us consider it to be really a good understanding of what's happening here. But that speaks to how sharply our perception of political reality diverges with our partisan identity. And we have to recognize that we too have a partisan identity, and it is likely shaping our perception of reality too. So, having said all of that, let's go back now to what happened in the Supreme Court. And I do want to go into some details on this, but let's start with the big picture, right? The question is whether or not, as president, Donald Trump has immunity from criminal prosecution for things he did while in office, the absolute immunity defense. And we don't know how this case is going to be decided. There are important forks in the road ahead, right? How do we count to five? Will the three liberal justices, the three Democratic appointees, uh, succeed in attracting two of the more conservative justices to vote with them? Will uh, the Chief Justice perhaps assemble a coalition in the middle? Will the conservatives find two or three more justices to side with them? I see multiple potential forks in the road here. I don't think that I'm alone or unique in this, but among the questions is, if the Supreme Court does decide that there's not absolute immunity, if it decides that there's absolute immunity, I will uh, again be shocked, dismayed about what I would consider to be an incredibly dangerous removal of the constraint of the rule of law on an office that contains perhaps the most concentrated power in our constitutional structure. And so just a horrendous mistake if that were to occur. I'm assuming that's not going to occur. The question is, what are the limits on the president's immunity, and how extensive, wide, or narrow are those limits? So that's question number one. And then, assuming that the court comes up with a holding that defines the limits on the immunity of the president, um, do they apply it to this case themselves, in their opinion? In which case, we could know by June whether or not Donald Trump will be on trial in the fall. But it seems to be much more likely that one of a couple other scenarios applies, which is to say, the Supreme Court, in its holding, defines the limits on the immunity of the president, but does not apply it to this case, and asks the court that's actually considering the case to make this determination, in which case that will take a while, and it's very unlikely that this case will go to court before the election, in part probably because whatever that holding is will be appealed and subject to further adjudication. Or alternatively, the court will say that this immunity defense doesn't work, although the immunity is not limitless, but does not offer a precise standard, and asks the judge to work it out. And then again, right, there's more work to be done. All of this to say, when this case was first announced, and I think this is important to bear in mind, that most people looking at it didn't think it would get to court before the elections of 2024. And that appears to me to have been exactly right. And so we shouldn't be as shocked or dismayed about this, even if we are a little worried that the Supreme Court took so long to hear this and is likely to further delay it. And that one upshot of its delay might be that this case will never actually see its day in court, because there's a good likelihood that Donald Trump will win the presidency and then order the Justice Department to shut this case down. Having said all of that, I actually don't think that is the most distressing development that we saw in court on Thursday. I think the most distressing development is what Justice Alito, and in different ways, uh, Clarence Thomas and Brett Kavanaugh, seem to indicate their understanding of the facts were, and the scenarios they were willing to consider, and the stance that they took with regards to this case, all indicate to me that they really are operating with a different lens on the law and politics of our society than, frankly, I had hoped and assumed they would operate with. So I'll come back to some of these questions, but I would point out to you again, it's important to notice that a man who is facing over 90 felony counts and four separate criminal trials just got the nomination of one of our two main parties to run as president of the United States. That's why we're focused on this right now. And again, it indicates that a substantial share of the American electorate does not trust the criminal justice system to establish basic questions of fact, does not view it as disqualifying to be the most powerful elected official in our country, that you are charged with multiple crimes, including crimes related to abusing power while in office, trying to overturn the outcomes of an election, jeopardizing the national security of the United States. And that's just a really important observation about the place we are in our society. And then it does also appear that the Supreme Court is really, uh, just like the rest of us, occupying rather distinct epistemic universes or worlds of truth that have rather little overlap on critical issues that they have to decide. So I'll be super brief about this. The place we're at, right? That Donald Trump is facing four different criminal trials: the classified document trial, the January 6th federal trial, the Fulton County, Georgia election interference trial, and the hush money trial. And that it does appear right now that the January 6th case is extremely unlikely to occur before the election. It also appears, and Fani Willis has seriously compromised her standing within this case. I think just a real mess. It was already an enormously complicated case because it's a RICO case. It involves um, a allegation of a conspiracy, and as you can see, many people involved in that conspiracy. These are tangled cases, very difficult to bring. They take a long time. The classified documents case could still go to trial before the election, but the judge in that case does not appear to be in any hurry to expedite it. And so I think that's quite unlikely. That really it's only the Manhattan criminal case that is going to go to trial, has gone to trial, is likely to produce a verdict before the election. I've already reviewed this with you. Let us get to what happened in the Supreme Court. And here I'm going to start and I'm going to contrast two different lines of questioning. The first from Justice Samuel Alito, and he at one point says, I'm not discussing the particular facts of this case," and there's some pushback from the the Justice Department's lawyer, but Alito asks instead, and this is quite typical of the arguments in front of the Supreme Court, for a counterfactual, a hypothetical case to be considered in which a grant of immunity from criminal prosecution is required for the functioning of a stable democratic society, which is, and now I'm quoting something that we all want. If an incumbent loses a very close, hotly contested election, knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And what this question reveals to me is that Justice Alito believes, I, it seems that something like this is plausible. And so plausible that as opposed to this being a rare, exceptional thing, happened only once in the history of our country over 220 years, because the conduct of one of our presidents was so bad, that this really is just an indication that we have become a more polarized country, that our legal system is increasingly being used politically to express that polarization in a vindictive way. And that might be one way to understand what is happening to Donald Trump in this case. I don't think Alito was willing to say that out loud, but something like that supposition seems to inform his line of questioning. Now, contrast that with Justice Ketanji Brown Jackson's question, right? If the president decides that his rival is a corrupt person and he orders the military or orders someone else to assassinate him, is that within, I'm sorry, there's a mistake there, within his official acts for which he can get immunity? And the lawyer for Donald Trump said that could well be an official act. There was some hemming and hawing, but eventually that is where he comes out. And I wish, frankly, that one of the liberal justices or the attorney representing the Department of Justice had envision the scenario. Let's say the president of the United States does not like what the Supreme Court is doing or how it's currently composed. Could the president of the United States order the assassination of justices in the Supreme Court? And that would be within the official capacity of his office, and so protected by presidential immunity. I think that would have helped to make this concrete. But to go back to Alito's case, right, and Alito's scenario here, it just is so, to my mind, transparently distorting of the way in which the law works, right? So assume that the law is going to be abused and then create the carve out via the Constitution to protect us from the abuse of the law. I want to say that the counter example that comes to mind for me here is, well, occasionally a person speeding and the highway patrol tries to pull them over, and as opposed to pulling over, that person tries to escape, and the result is a dangerous situation for everyone concerned. Should we therefore not enforce the speed limit? Right? The idea that we have to not enforce the law against the president of the United States because it might lead him, make it clear what Alito is saying, to not want to get out of power if he loses the election, just seems to me to be um, a very different world from the world I live in. And so how did Alito come to conclude that that is the right framework of thought to bring to bear on this case? And to explain that, I now want to move away from this case and these arguments and into some deeper jurisprudential issues to do with the role of the Supreme Court and its justices, the Constitution, and judicial review in American democracy. And I want to contrast three views with you and to do it very quickly, but to give you a sense of three different ways of thinking about the role of a Supreme Court justice in the United States and in our constitutional democracy. The first view comes from Ronald Dworkin, probably the greatest English language legal philosopher of the last 50 odd years, a towering figure in jurisprudence, author of a whole bookshelf full of books. I'm just putting Freedom's Law because it has the moral reading of the American Constitution in its subtitle. And here, Dworkin, and in an earlier book, Lawless Empire, lays out this idea that we should treat our judges, and in particular the justices of the Supreme Court, as Hercules, because they have to take on this Herculean effort of understanding the Constitution's moral principles, hence the moral reading of the Constitution. The idea that the Constitution doesn't just contain an architecture for institutions and an enumeration of certain rights, but that implicit or explicit within it are certain more general moral principles, and that it is up to the judge, on the one hand, to discern and defend those principles as the unifying normative underpinnings of the Constitution, what gives it force for us, and then to interpret the core abstract moral commitments of the Constitution in light of the morality of justice of the people of the United States in the moment in which they're writing. Does the protection, equal protection under the law, extend to issues of gender equality? Might that be a grounds for instance, protecting a right to abortion? Does it extend to equal rights for homosexuals to engage in sexual intercourse in same-sex sexual relationships, or to marry each other if the state is in the business of recognizing marriages? And obviously, for much of our history, our justices and judges did not read those provisions in that way, but later they did come to read them in that way. And part of what Dworkin is suggesting is that that is the right and good thing for the justices of the United States to do. It is, in fact, their role to bring the morality of the people to bear on the principles that are articulated in the Constitution. In this sense, the Constitution serves not only as a barometer of our moral learning and evolution, but also perhaps as the cutting edge progressive institution within our government that forces the pace of moral change as the justices stand above the partisan fray and ask what our core moral commitments are in this or that historical moment, as opposed to Dworkin's view, which obviously assigns great significance and importance to the Supreme Court and the justice and the role of judicial review in our democracy. Gerald Rosenberg, a contemporary political scientist and law professor at the University of Chicago, and I think the disciplinary uh, difference matters, right? Ronald Dworkin is a philosopher and a law scholar by background. He's interested in working out a philosophical theory of the justification for judicial review and the role of judges in a constitutional democracy. Um, Rosenberg is much more interested empirically in how the court actually operates. And in his book, The Hollow Hope, which is now in its third edition, very recently published, I think published just last year, the third edition, makes the argument that courts are reactive institutions, that they're very often conservative institutions. The Supreme Court of the United States gave us Dred Scott and Plessy v. Ferguson long before it gave us Brown v. Board of Education. And not only that, when it gave us Brown v. Board of Education, the people of the United States had already become progressive about civil rights. It was not on the cutting edge of registering our moral learning. It was merely reactive and basically conservative as it always is. And so the Supreme Court is not driving social change or learning or progress in American society. More often than not, the opposite is the case. It's an institution captured by vested, powerful interests who, once they manage to capture the court, are more representative and accountable bodies. The president, the Congress may continue to evolve and change, and the court actually gets in the way of that change. And so, right, the polar image opposite, and certainly I would guess that Rosenberg is having a field day with what's happening in the Supreme Court right now. Ronald Dworkin, by the way, has been dead for about 5 years. And so he's not here to give us his reflections. I would so much love to hear them. Uh, the final thinker, I've spoken with you about Larry Kramer before, a long time member of the NYU Law School, person who's in part responsible for building it up as one of the top law schools in the United States, including hiring Ronald Dworkin. Uh, in this book, The People Themselves, Popular Constitutionalism and Judicial Review, Kramer makes the more nuanced historical argument. And so there's a third method here, a historical method, that the people of the United States have for long periods viewed the Constitution of the United States as an expression of their popular sovereignty. It's our Constitution. It's written in our name. It should be interpreted in light of our views about its meaning. But that there's a natural institutional dynamic for the Supreme Court to want to not serve as our principles in maintaining the Constitution, but to aggrandize power to themselves and to very often serve the vested interests that people like Rosenberg point to as determining the appointment of justices to the court in the first place. And so, to the extent that a reading of the Constitution that reflects the ideas of the people of the United States is actually informing Supreme Court decision making, Kramer suggests it's only because the people of the United States, especially through their elected leaders in Congress and the presidency, force the Supreme Court to do this. And so, to be as clear as possible, right, Dworkin is suggesting constitutionalism, judicial review, the justices tends to be and should be understood as intrinsically progressive, right? Rosenberg is suggesting it should be understood the opposite way. It's intrinsically conservative and often hostile to democracy. Kramer is suggesting a third position. Dworkin is right some of the time, Rosenberg is right some of the time, and that depends really on the politics surrounding the interpretation of the Constitution and whether or not the people of the United States choose to elect representatives who will force the Supreme Court to acknowledge and act on the basis of popular understandings of the Constitution. I want now to put those three understandings to the test in what's happening in American politics today. And very briefly, I'll just mention to you the work by Nathan Kalmo and Liliana Mason, which I've described to you before, on radical American partisanship. This is the study that finds, right, that 60% of Americans believe that the other party is a serious threat to the United States, that the opposing party is not just worse for politics, they're downright evil. 40% of Americans agree with that. That members of the other party are subhuman, more like animals. Nearly 20% agree with that. And I just want to be as clear as possible. I don't think there's any reason to exempt the justices of the Supreme Court from radical partisanship. What Dworkin would say is that's not their role. They are not partisan officials. Once they put on those robes, once they enter our temple of justice, their role, their fidelity is to the Constitution, not to their party. Rosenberg would say, absolutely not. There's no magical threshold that you go through when you enter the court that wipes away your partisan identity. You're still the same person you were before you put those robes on, and the history of the court shows that to be the case. Whereas Kramer would say it's a little bit more ambivalent. We can perhaps, through our politics, force our justices and federal judiciary to act as constitutional partisans and not as radical partisans in the ordinary sense. So let me finally connect all of this to something I've been thinking about. And to be honest, I wasn't going to speak with you about this for probably a number of weeks. But what happened in court on Thursday has prompted me to start organizing some of my ideas on this. And so what I've been thinking about and the provisional title of a series of talks that I'd like to share with you is, can 21st century democracy survive social media and artificial intelligence? And so that's the big topic. The relevance for today is the suggestion that our identity shapes our cognition. And I'll say a little bit about this, and that our identities are becoming increasingly partisan and sorted, and that the result is that our cognition is increasingly uh, informed by our partisan identities, and that that is not healthy for democracy. And what I see from Justice Alito is, it seems to me, indicative that this kind of partisan motivated reasoning is infecting the institutions that we most hope are immune to it, the Supreme Court of the United States. And to be as clear as possible, I do my best to be even-handed. I do my best to try to check my own motivated reasoning. I don't claim to be infallible or objective or impartial all the way down. I know what I say is controversial and that there's a politics and a morality informing it. But I do have to say, from the vantage I occupy, I am worried that we are increasingly polarized and shaping our cognition to confirm our polarized identities. And so part of the issue here is the emergence of stacked identities, and the idea that when you know someone's partisan identity, you know their racial identity, you know their geographic identity, you know a lot about their religion, their education, their place in the economy and social hierarchy. Not that partisan identity is perfectly predictive of all of those other identities, but there is this increasing sorting in which, if you are a white person who is not happy about the growing diversification of American society, you're much more likely to be Republican. If you are ex-urban or rural or from a small state, you're much more likely to be Republican. If you are agnostic or not part of an organized religion, much more likely to be Democratic. If you're a woman who believes in equal rights for women, much more likely to be Democratic. So that as opposed to being cross-cutting coalitions, our partisan identities sort all kinds of other relevant social identities, including ascriptive identities, religious identities, geographic identities. And so if we call these stacked identities, right, that they tend to reinforce motivated reasoning, reasoning that is designed to confirm that identity, to protect that identity. And so I'm referring here to various contemporary authors in cognitive science, in psychology, who have helped to illuminate confirmation bias. We have a much easier time processing information that confirms what we already believe, that we are very uh, adamant about finding arguments that protect the core constituents of our most important identities, that we tend to be much more sympathetic to the side of the argument that supports what we already believe than to the other side of the argument. And so there's a whole literature on this, and you put that together with the growing polarization of political identities, partisan identities, as subsuming identities or stacked identities. And you get a clear scenario in which in group, out group thinking takes hold and really shapes our processing of our social world. And so if that is correct, and it's not just that we as individuals are shaped by our cognitive biases, but that these biases increasingly inform our media system, our partisan competition, the perception of reality enters feedback loops that structure our contemporary public sphere. And depending on where you stand, which of those feedback loops you belong to, you end up with a very different reality. Um, I want to then add very quickly, in terms of the Supreme Court, that there's a reason that we have six Supreme Court justices who were selected on the basis of their adherence to a constitutional philosophy, sometimes called originalism, sometimes called textualism. We've talked about this together quite recently. The idea that it's not up to the judge to find the moral principles contained in the Constitution and interpret them in light of the current ideas about justice and morality of the American people. They are bound by what that text originally meant, or what it meant to the people who ratified it, or what the intention was behind putting that provision in the Constitution by the people who framed it. And this is an intrinsically conservative reading of the Constitution, but I want to suggest also that it is shaped by a politics, and it is a kind of culture war politics that suggests that the United States has become much less Christian, much less traditional, much less white, and that in many ways the culture that informed our Constitution and democracy and made us a powerful and great society has been eroded by these developments, and that what the role of the Supreme Court should be is to preserve a more traditional reading of the Constitution, and in so doing, to stem the out of control galloping of the United States into a moralism, into atheism, into a multiracial society that loses the culture that has sustained our practices and institutions for 200 years. And so that justices like Alito and Thomas and Kavanaugh are there precisely because they represent a view that much of the moral reading of the Constitution and progressive law have been a mistake, right? And so this means that the culture war is occurring inside the Supreme Court. And I'm going to conclude. I know I'm running out of time with a final suggestion. I'll maybe go into some of the other details next week. But the question is, what kind of judicial identity mitigates against identity protective cognition, right? And so if we want the justices of the United States to not be as prone as we ordinary partisans are to partisan identity protecting, bias confirming, my side thinking, what identity should we want them to have? And there I want to suggest that there has to be a distinct judicial identity that provides them with distinct cognitive interests. That if I conceive of myself not as a partisan per se of this party or that party, but primarily as a citizen, and if my interest as a citizen is in not being subject to biased, disinformation formed thinking. If I believe I have a duty as a citizen to hear those with whom I disagree for partisan reasons and to assess the quality of their arguments, the validity of their claims. And if that identity is more important to me than my partisan identity, my identity may give me cognitive interests, identity protecting interests that lead me to want to be less partisan, more impartial. And I'm going to suggest to you, I'm going to have to leave it brief today, that there is a judicial version of that identity. That the judges, and especially the justices, primary responsibility is to the Constitution, not to a particular party, and that appropriately understood judicial fidelity, the judicial virtues, should mitigate these kinds of biases. But if what we're seeing from the Supreme Court in the hearings on Thursday and the arguments, and more generally indicates that the court is not behaving that way, that justices on the court seem to have a different self understanding, then it's up to us as a people to begin to try to change the composition of the court, but also to express our indignity at the way in which the justices are construing their power and their uh, duty or responsibility within our system of constitutional government. And that's going to be slow, that's going to be long, that's going to be hard, it's not going to be easy. But in the short term, I do think that perhaps there's a scenario in which Chief Justice Roberts, in which Justice Amy Coney Barrett recognize that enough of the people of the United States are not simply part of the Fox world of information, and that if they decide on the basis of a clearly partisan epistemic stance, that they will damage the court, its legitimacy, its standing with most of the people of the United States, and that ultimately that might just serve as something of a check against a highly partisan and motivated judicial mode of decision making. All right, why don't I stop there? I know I've gone a little bit over. Want to hear your questions, your thoughts. I know I threw a lot of information at you today. Who wants to start us out? Were you as distressed as I was by what you heard coming from the conservative justices in Thursday's hearing? Were you paying attention to this? And if so, was it a moment where you said, "Oh my goodness, the court is not quite the institution I thought it was today"?
Yes.
You are going to have to unmute yourself, which means pressing your.
Yes, very, very definitely.
Yeah, yeah, and I hope that the analysis that I presented today helps you to understand maybe a little bit more where someone like Alito is coming from. Again, I'm still a little stunned by the idea that he thought what he said what was a good argument to hear from the bench. That it's more dangerous that the president of the United States be concerned about partisan prosecution coming after he leaves office than it is that the president of the United States understands himself to be unaccountable for any violation of the law he engages in while in office. When I put those two things in the scale, I know which side has the weightier concerns in it, but apparently Samuel Alito has
You
a
can
very
throw
different.
those things over here.
Anybody else with a comment or a thought for today? Or Hannah, did you want to say more?
No, except that we expect teachers to give up their personal kind of views. And we do not expect this of our Supreme Court. I've watched it happening, but I'm still in a state of shock and worry about what this means for not just our democracy, but
I think you cut off there at the very end, Hannah, but I completely agree with you. I want to say maybe one more thing, which is we should be very careful not to assume that we have a monopoly on impartiality or truth, right? And so I know that I too am subject to partisan bias in my reasoning. I try to overcome it. But having said that, I may at points fall prey to it. And so I think I want to be careful not to say that it's all on one side. I will come back and I will suggest to you that it's much more on one side than it is on the other. And there are reasons for that, and that makes our task in this situation all the more difficult. A substantial portion of the American population has for quite a while come to mistrust the institutions that verify the plausibility of the information and knowledge that we share. I think we saw this very clearly in the pandemic and the mistrust of public health officials' advice and of vaccines. But having said that, um, how do we, first of all, establish our own bona fides, the fact that what we believe is in fact credible? I think it's only by encountering with respect people who disagree with us, hearing out their arguments, evaluating them on their substance, not dismissing them because they come from the other side, and then seeing if their arguments are better than our arguments, and hopefully doing this in a diverse setting where there are multiple people to weigh in and expose our biases if we're using them to structure our cognition. And that is essential to democracy, and it seems to me increasingly scarce in the 21st century, including in the Supreme Court. So, Barbara, I see you've got your hand up. Go ahead, please.
Yes, I want to add to Hannah's point about teachers having to be presenting instruction with a non-political bias. My father was a federal government worker for more than 30 years. And as kids, we wanted to put up political signs in our front yard in Palo Alto, 30 miles away from where he worked in San Francisco. And Dad said we couldn't do that. And we couldn't have bumper stickers on the car or any of that sort of political advertising about our values and preferences for party. So I think the idea of having judges somehow either put aside or come without partisanship is a good one. Probably very hard to implement, but worth thinking about and pressing for.
And again, I think I need to be as clear as possible about this, because I don't think, that there's a partisan and a nonpartisan way of evaluating, complex questions of fact or law. There are diverse arguments, and those diverse arguments are always shaped by the perspective of the people who are evaluating the reality and making the argument. But having said that, recognizing that we all tend to have certain biases and that we all operate from constitutive perspectives. My perspective, my life experience, my standing within this society, my values shape what I see, what I pay attention to, what I think is significant. That's the nature of being human and operating in a world with so much information that there's no way to simultaneously account for it all. I have to decide what I'm going to focus on. And so I don't want a teacher who says, I am the arbiter and the absolute authority on these issues. I think that that's a pretense that they cannot be defended. It's part of what bothers me about Ronald Dworkin's metaphor of Judge Hercules. None of us are Herculean in our intellectual capacities. Some of us have more capacity, some of us have less capacity, but it's always a mix of the perspective and the information I choose to pay attention to from that perspective. But having said that, to acknowledge that is part of being more impartial, more objective, part of saying, I don't have the monopoly, and therefore I have to hear the arguments on the other side, and then I have to consider them. And what worries me is how motivated the reasoning on the court appeared to be on Thursday, and how little of those judicial virtues I seem to hear from some members of the court. I'm going to have to make a more elaborate argument to you to explain why I'm pointing at Alito and not pointing at Brown Jackson or Sotomayor. I think that I have good reasons for seeing it more on one side than the other, but more information needs to be developed. That's where I'm going with this idea of whether or not democracy can survive social media and AI. Anybody else with a final question or comment for today? let's go ahead and call it a day then. Nice being with you as always. Have good weeks. I look forward to seeing everyone next week. Take care. Thank you. Bye, guys.
Bye.